We are very excited that we are all getting vaccinated. The world is opening back up again. We're booking trips later in the year, not this moment. I hope you are all well and safe, and we're going to start with our Ask Me Anything questions today. First question, my daughter left no will, but had me as the beneficiary of all she had. Do I need to go to court for anything? Her bank accounts, life insurance, her house were all under both our names. First, I'm so sorry to hear you lost your daughter. I usually tell my clients one of the hardest things that you can go through in life is losing your parent, but oh my God, losing a child, that's pretty intense. So I'm very sorry to hear that. So you were named on everything and there's nothing else that she has. Yeah, whenever a client comes to me and says my loved one has passed away, before I even ask on whether or not there's a will, the first thing I want to know is, did your loved one have anything that was jointly owned between you and anyone else? Co-ownership avoids probate. So if your name was on all of the assets, the bank accounts, the house, then you are automatically the owner of that asset at the time of your daughter's passing. Nice and simple, okay? Now, what happens if you're not listed as a co-owner? The next bucket, the next question I ask about is, did your daughter or you, whoever, your loved one that passed away, have anything that had a beneficiary designation listed on it? Were you listed as a beneficiary on the bank accounts, the life insurance? So your daughter had you listed as a beneficiary on the life insurance policy. So because of that, that avoids probate. So the first bucket, co-ownership, avoids probate. The next living co-owner gets title to the asset. Beneficiary designations, that is a contract between you, the institution, and your beneficiary. So they automatically get that ownership there. And then the next thing from there, after that, everything falls into what's called your probate estate. That is everything else that didn't have a co-owner, didn't have a beneficiary, and now your will controls at this point. So even though your daughter didn't have a will, because she had you listed as co-owner on some things and beneficiary on everything else, and there's nothing left, there's no probate. And all of it comes to you. You do not have to worry. Now, if there is something that maybe doesn't have you listed as a beneficiary, like maybe one bank account here or there, then yeah, you're probably going to have to go to probate unless the total value of what's left over after those first two buckets are hit is less than a certain amount. And in every state, that amount is like $100,000. In California, it's $166,000. So if you have less than $166,000, or if your loved one had less than $166,000, you're not going to court. We think you don't have enough money to deal with court. That is called a small estate. You just hire an attorney to help you make an affidavit of small estate, and we can transfer your assets over. All right, next question. How can I allow my wife to remain in my home until her death and then allow my children from a previous marriage to inherit the home? This is a nice, noble thing. I'm glad that you want to take care of your wife. All married couples should take care of each other first before anyone else. But yeah, you're right. You want to prevent your wife from becoming that evil stepmother, or as we call the Cinderella effect. And you want to make sure your children from another marriage inherit some of your estate, right? So the best thing you can do, there's two ways to do this. In your will, you can leave your home to your wife in what we call a life estate. Basically, you're letting her have it for her lifetime, but after her lifetime, it goes to someone else. She has no control over who it can go to. Now, the downside with that is you have to go to probate to have your will read and for that to apply to your wife. Alternatively, you can create a trust. A trust is a little more expensive than creating a will, but it gives you privacy and it ensures you're not going through a long, expensive court process after your death. In the trust, same thing, just like a will. You can say, I leave the home to my wife for her lifetime, and upon my death, it is going to go to my kids. Nice and easy. It's actually a very easy thing to do. It sounds a little complex, but it's not. And from there, you can put in protections on what if your wife becomes a paraplegic or gets so old to the point that she needs Medi-Cal or other kind of funding. And this is how you can help protect her for her long-term care planning, protect her for life with any other kind of income. And then the principal, not just the home, you can actually create a sub-trust. We call it the marital trust, where you're protecting your spouse during their lifetimes. And then whatever remains, the principal that was preserved, goes on to your kids, and she doesn't have an ability to have a say over that. One thing to keep in mind, we live in a community property state. What does that mean? That means when you get married anything you earn or acquire during your marriage is community property. So you don't have a say on the full value, what happens next on the community property. You only get to have a say on 50% of it. So you can say, my share of the home, that's community property, goes to my wife for her life, and then it goes to the kids, but the wife will still have her own share. In other states that aren't community property, like California, they have a more separate property regime, but there still might be something called the marital election, where the surviving spouse can elect a portion of the decedent spouse's estate should something happen. So it can get complex with marriage. If this is your own separate property, your own home, you've had it before you were getting married, you most certainly have full control on what you can do there. But that's where you should probably be talking to an estate planning attorney to help you decipher whether you can actually do this with your home or not. In terms of design, very easy to do. In terms of whether you have that ability, based on what kind of property this home is it community property, separate property? That you're gonna have to talk with an attorney about or figure out more.